So we're looking at ancient documents, and this is Rule 803.16. And the rule doesn't really give us a whole lot to go on by itself, simply that a statement contained within a document that was written before January the 1st, 1998, is an exception to hearsay. Now, why would we have such a rule? And I think, like a lot of the rules we've seen in this class, they're driven by necessity, that there would simply be no other way of getting the evidence that would be contained within an ancient document in. The witnesses who would have seen an event, would have known about an event, the author of the document may not be available any longer, quite possibly has died. So this is a rule that we've seen as elsewhere, 404B, for instance, with the Beecham case. We talked about how that there are rules that are driven of necessity. And I think this is absolutely one of those rules. And I think that the first case we look at, the Firishchak case, is a great example of how a great example of a set of facts that we simply could not establish without using these ancient documents. So in this case, the appellant had previously been granted a visa after World War II as a displaced person. And of course, after any war, there are going to be people who no longer have a homeland for a variety of reasons. And so he was able to come to the U.S., was able to get a visa to come to the U.S. But much later, it was discovered that he had worked with the Ukrainian auxiliary police that had been employed by Nazi Germany to do some pretty awful things during the war, to harass, interrogate, kill Jews in the Ukraine. And so the question is, are the documents that establish that he worked with the Ukrainian auxiliary police, are those documents admissible under this exception for ancient documents? Well, they're certainly very old. They're from the early 1940s, certainly well before January the 1st, 1998. But what other conditions must these ancient documents satisfy? And the defendant says, well, or the appellant, Firishchak, says, look, that these documents, some of them don't have a date on them. Some of them didn't, and that's true. One of them, I think, did not. Others did. And that they weren't filed in the ordinary course of business of the Ukrainian auxiliary police. At least the government hasn't established that these would have qualified as ordinary record keeping by the Ukrainian auxiliary police, and giving them the degree of authenticity that we would have for a business record. And the court quite rightly notes that, look, for ancient documents, you obviously don't have to satisfy all the requirements for a business record, or otherwise we simply wouldn't even bother to have something in addition to a business record. If you can establish that this is a really, really old document, and in this case they did so by having a witness talk about the fact that this document was stored among all the other documents of folks who had worked with the Ukrainian auxiliary police, then those documents are in fact admissible as ancient documents. So again, this is a rule largely driven by necessity. If we need to find out something that happened from a very, very long time ago, there might be journal entries, there might be all kinds of things you'd find in historical archives, letters that were from the 1800s, the early 1900s, that we couldn't otherwise prove. Let's say the date of Ulysses S. Grant's death was somehow relevant. Now there would be documents in the records of vital statistics that would establish this. But what about his time of death? Perhaps if his wife had written to one of their friends and said, Ulysses passed away at 3 o'clock in the afternoon. I'm not sure which time he died, but let's say it was 3. Then there may be no other way of establishing such a fact. And if that's relevant, then this is some proof that's better than no proof. You can argue to the jury how good it is, but we would deprive ourselves of something which may not be able to be proved any other way for these documents that are considerably older. And so Firishchak really does show us an example of something that we couldn't have established really through any other means. All the people who could otherwise establish this fact are now dead. So, or likely now dead. So this case shows you a great example of why we have such a doctrine, and the fact that the exception here is simply for an old document. Show me that it's old, and I'll let it in. That's what a judge has to say under 803.16, the exception for ancient.